Hello, my name is Andrew H. Griffin III. I'm a California bankruptcy attorney with over 35 years of experience. What happens if you're separated but not divorced and you want to file bankruptcy? The modern view of marriage is a 50-50 partnership. The Bankruptcy Code turns that proposition on its head. All of a couple's community property comes to the bankruptcy estate when one person files bankruptcy. There's no my half, your half. If it's community property, it's an all-in when either spouse files. A happily married couple with a debt problem may see that result coming. They've met together with a lawyer and they've spotted reasons why one spouse should file bankruptcy. Divorce, but not divided. It can be a brutal shock if, like many divorcing Californians, the couple has terminated their legal status as married persons, but left for later the division of the community property. So often, that division is complex and contentious. It's easily put off to another day. When one former spouse files a bankruptcy case, all of the couple's property becomes subject to the control of a case by a trustee or the debtor if the case is filed under Chapter 13. It doesn't matter that the non-bankrupt spouse is living in the community house or running a community business. The community property is the property of the estate. The good news is that all of the couple's community debts are properly claims in the case. That may be a help to the non-filing spouse if there are non-dischargeable tax debts left from the marriage. Exemptions and exclusions. All is not necessarily lost if you are the non-filing party. Any property that is exempted from the estate is still subject to division between the couple. Often retirement assets are the most valuable asset that a married couple has acquired during the marriage. Pensions, public retirement benefits, and 401k plans are not property of the state, even if they are community property acquired during the marriage. But state law controls characterization. The Bankruptcy Code looks to the state law to characterize whether property is community or separate property. So, state law will drive the bus on what is community. Federal law will tell us what happens thereafter. So in summary, if you live or have lived in a community property state, you need to consider the risk to your contemplated division of marital property if your ex files bankruptcy. Make sure your family lawyer is familiar with community property issues in bankruptcy or bring in a lawyer who is on top of these issues. This is Andrew H. Griffin III at andrewgriffinlawoffice.com. Today we are helping you understand the bankruptcy process. If you want to learn more about bankruptcy, go to andrewgriffinlawoffice.com to get a free copy of my book.